Hello guys, my name is Sini Isaac and today I will be speaking on the topic Problems Facing Public Interest Litigation in India. The traditional rule of locus standi implies that only a person whose rights has been infringed can file a petition before the court. But the apex court has allowed relaxation in this rule by incorporating the concept of public interest litigation, which means litigating before the court of law for the interest of a larger public. It is an instrument provided to the public spirited person to seek redressal for the violation of the rights of the public. But there are certain problems faced in public interest litigation which tends to transform this instrument into a form of a weapon, which thereby tend to prejudice the success of PIL in India. Some of the problems faced are: first, publicity under the veil of public interest litigation. There are numerous incidents in which it has been observed that the irresponsible citizen impair the essence of PIL and use it as a tool for gaining publicity. The word P in PIL means public and not publicity. It is one of the major problems faced in this form of litigation, as litigation, rather than using as an instrument in a constructive way, it means or became a mean to get a popular or coming into limelight. Some of the recent cases of this kind of abuse are: a PIL was filed against the case or a movie called Kedarnath on the ground that such film hurt religious sentiments, as the movie shows a Muslim boy at Kedarnath falling in love with a Hindu girl. The court dismissed the petition as a publicity stunt. Second was a PIL filed seeking the medical evaluation of a chief minister was filed at the Bombay High Court. The court dismissed the petition as publicity interest litigation, as the petitioner did not disclose the facts regarding his political affiliation and made baseless allegations. Second is judicial advantageism. Judicial overrule or overreach occurs when the judiciary interferes in the sphere of executive or the legislature and violates the separation of power enshrined in the Article 50 of the Constitution. Some of the instances of judicial overreach in the public interest litigation are: a petition was filed in the High Court against the certificate granted to the film Jolly LLB 2, and the Bombay High Court ordered to cut 4 scenes on the ground of being defamatory to judiciary. It is an instance of unnecessary interference, as under the Cinematography Act 1952, courts have no power to refuse, modify or certify the certificate granted to the film. Second was a PIL related to road safety and problem of drunk driving. The Supreme Court banned the sale of liquor among the states and national highway. It applies to all courts and restaurants within 500 meters of highway under the ban. It was an administrative issue and the court was not an appropriate authority to pass such an order. Third is symbolic justice. PIL reflects symbolic justice, as sometimes the direction issued in the PIL are not implemented, which thereby affects the credibility of judiciary. The apex court in Vishaka versus State of Rajasthan and DK Basu versus State of Bengal issued direction related to sexual harassment, procedure of arrest, etc., but often it is unable to check its compliances. Fourth is obscure motives of the litigants. It is a general principle of the law that one should come clean to the court. But sometimes this personal grievance or political motives are masked under the public interest litigation. Such PILs could be dismissed and courts should not proceed further with them. However, sometimes it becomes a deficient such ultra motives, and hence this destroys the essence of PIL. Though by series of judgments, various guidelines have been laid which are to be followed while entertaining PILs, also it is being misused as no heavy court fees are involved in the case of an ordinary civil proceeding. Fifth is tremendous increase in litigation. Due to the flexible and non-complex process of filing a PIL, the filing of indiscriminate petition creates a lot of pressure on judicial system and delays the process of disposal of bona fide petition. Sixth is institutional limits. There are major need for structural change in the operation of PIL cell. In case of Nilima Priyadarshini versus State of Bihar, a written letter by a person who was illegally detained was placed before the court 2.5 months after the PIL call had received it. Another serious institutional limitation is that the bench structure keeps on fluctuating. So, from the above analysis, we could conclude that PIL is a tool which can easily bring any case in the eye of law without proper litigation process, and cost it has some booms which are cured by the court, but still there are some loopholes in which court have to work so that there is no misuse of public interest litigation by any means. Thank you.